is for this session. As we all know that all the three laws have been given an indic name, Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita and Bharatiya Sakshya Adhiniyam. So what is really this transition which you can highlight from Dand to Nyaya, and what could be the underlying philosophy for this shift from Dand to Nyaya? If you can kindly underscore that and enlighten the gathering here about this switch from Dand to Nyaya in these laws.
The legislation has been given an indic name, as you pointed out, part of your question. There is nothing objectionable in giving the new statute on substantive criminal law an indic name. English is a colonial language, and while it may be difficult, at least at this stage, to replace it as a medium of discourse in courts, independent India needed to shed its colonial baggage, starting with colonial era legislation. Nobody in India spoke English till the East India Company, by a royal charter, became first India's main trading partner and later a private colonial power. I welcome the new nomenclature of the statutes, although I am predominantly English speaking, because it heralds indigenous legislative output as opposed to alien imposed legislation. Now, the second part of your question. In discussing the philosophical rationale of the Bharatiya Nyaya Sanhita, it is first important to emphasize that the transition from Dand to Nyaya does not entail sweeping changes in the law that the Sanhita replaces, that is the IPC. There is a very nuanced shift between the Sanhita and the code, from a code that was predominantly concerned with the deterrence of crime through punishment or dand. We have moved to a Sanhita which, while retaining the deterrent aspect of the code, introduces provisions which focus on providing justice, nyaya, to all stakeholders. In a nutshell, this is what the Sanhita is designed to provide. It aims at providing safety and security to potential victims of crime. It introduces the reformative aspect of punishment as a community service, for instance, community service and compensation to victims, as opposed to the singular pursuit of deterrence. The thrust of the code was to deter punishment, to deter commission of crime by deterrent punishment, going up to the death sentence. Here, on minor offenses, there's an attempt to move towards the reformist aspect of punishment. It replaces provision of the code. Now, this is very important, and later I'll come to it. It replaces provisions in the code securing the safety, in the Indian Penal Code, securing the safety of the colonial regime and its citizens from its colonized subjects, and it replaces this aspect with those enhancing security of a democratic state and its citizens from internal and external and internal subversion, recognizes that women and children are most vulnerable to criminal activity, and introduces provisions for their security or suraksha, as also provides for sensitivity, sanvedanshilta, and compassion, karuna, for the differently abled sections of society. The preamble of the Sanhita, now this is important because this is not a sweeping change. The preamble of the Sanhita emphatically states that the act is not a complete break from the code, but a reformist exercise, amending provisions of a colonial past befitting to Indian independence, independent India. Now, this is what the preamble states, and that summarizes everything. The preamble states that the Sanhita is an act to consolidate. So it's a consolidating act. And most of the Indian Penal Code provisions, at least 80%, find their place in the Sanhita as well. So it's an act to consolidate and amend the provisions relating to offences and for matters connected therewith on incidental thereto. Now, how the philosophy of the new statute, the Sanhita, the Nyaya Sanhita, plays out in practice, what are the provisions which seek to achieve its aims, is an answer to your 10th question, which is the last question, which you will pose to me, no doubt.
Yes, sir.